I'm Chris Bebel. I'm a former SEC attorney and I'm a former federal prosecutor. At this juncture, I devote much of my time to representing investors who have been defrauded pursuant to the sale of a security. So, let's get after it. What are we going to talk about today? In a nutshell, we're going to talk about the Securities Arbitration process. Now, you may not be aware of this, but in many instances, customers are required to arbitrate the disputes that develop between them and their broker because they have signed an arbitration agreement. Now, that's not always true, and sometimes a case can still go forward in court. But let's look at the arbitration process. In all probability, your case will be filed with FINRA. FINRA stands for Financial Industry Regulatory Authority. FINRA is not a government entity, but its operations, its day-to-day activities are overseen by the U.S. Securities and Exchange Commission. Now let's take a step back and let's look at the features and characteristics of the average FINRA arbitration proceeding. First of all, a statement of claim is filed. That's the name of the pleading. And FINRA does not enumerate lofty, demanding standards for those who are preparing a statement of claim. To the contrary, it merely requires that the statement of claim, that the pleading, reflect a brief discussion of the underlying fact pattern, and it must identify the relief that is requested. In other words, the statement of claim must tell FINRA, it must tell the arbitrators how much money is being sought. Now, after the statement of claim is filed and after the respondents are provided with an opportunity to file an answer, the discovery process begins. Now, it's fair to say that the discovery process in FINRA arbitration cases is far more limited vis-a-vis court cases, but you will nonetheless be allowed to issue requests for production of documents. Those requests, in all likelihood, in all probability, will help lead to certain important documents, pivotal documents, that help flesh out the details of the case. Now, when the case is presented before the arbitrators, it'll start with opening statements. It'll then go to a presentation of the evidence, wherein the claimants will put on their case. In all probability, they'll put on the broker, maybe the supervisor of the broker, maybe a compliance officer, the customers, in other words, the claimants will testify, and an expert witness who has been retained on behalf of the claimants will testify. The defense will then put on its case and closing arguments will be made. After the arbitrators have had an opportunity to reflect on the matter, they will then issue an award, and in a nutshell, that's probably the conclusion of the case. Now, it's important to keep in mind that FINRA arbitration is far less expensive than litigation in court, generally speaking. And that's because depositions are not taken in FINRA arbitration cases, and it's because the parties do not need to retain expert witnesses during the course of the discovery process. Now, obviously, this is comprised of generalizations. We're painting with a broad brush, but hopefully this nonetheless enlightens you as to the basic characteristics of a FINRA arbitration proceeding. If you have any additional questions, just go to my website, chrisbebel.com, or you can give me a call, 903-843-5678. Thank you.